Today's topic is important topic for you. Section 6 and 14 of Hindu Women's Right, which is amended in the year 2006. So this fact has been brought in the Act in Prakash versus Fulvati case at Karnataka. Whether the women are having an equal right or not, then it was some of the condition has been imposed in that case. The matter went to Supreme Court, and there it is decided once again in Mr.N.R.Naik case, and it has been overruled, stating that the section 6 is only by way of birth of woman who is none other than the co-partner in a joint Hindu family. So it is only Hindu woman's right has been confirmed under section 6A, which is brought into the effect. So what happened in this case? First, previous this section is not available. In Kannada proverb is there, Kotten Kulukvarakke. After married, she is not entitled any share from the family which is she has left after the marriage. Therefore, what happened, whether the section 6 incorporated by way of amendment, that is in the year 2005, and it has been brought into effect 2006. That is the date, kindly maybe note down, 2012-2005. It has been brought as an enactment, and effect has been given 1/1/2006. So when this act has been incorporated, then all the women, they have started to claim the right over the property. Certain conditions are laid down in the said section 6 who can claim the right over the property. That is the section incorporated in the said enactment. Now, I want to read the section 6A. That is what it says. What it says, equal rights to the daughter in a co-partner property. That is the section 6A has been incorporated with its effect from 3790, that is the 2006. So this act says, notwithstanding anything contained in section 6 of Act 1, in a Hindu joint family governed by Mitakshar law, the daughter of a co-partner shall become a co-partner in her own right in the same manner as the son and have the same rights in the co-partner property as she would have had if she had been a son, inclusive of right to claim by survivorship, and shall be subject to the same liabilities and disabilities in respect of thereto. So this means to say section 6A incorporated in this section Hindu Succession Act, stating that by birth itself woman is also right what the son is enjoying the right in a Hindu joint family. So that is the proverb I have stated, because immediately after her marriage she can't claim any partition from the suit schedule property, that is the co-partner property. When co-partner property, what it says, only the Hindu co-partner properties. After this amendment when has been brought, every daughter of the co-partner property, she is entitled for partition. In some cases, what happened, when this enactment is incorporated, immediately some of the knowledgeable persons, they have started to getting the Panparikat or otherwise unregistered partition deed took place among the family members. Once the partition was took place, the daughter she cannot claim. That is the defense they have started. Then whether the Panparikat is enquirable before the court of law, yes. Whether the co-personary property is partition by way of unregistered partition deed can be questioned the daughter, yes. That is the case decided in Fulvati versus Prakash case before this honorable court, first case, because the some terms and condition what happened in that case, though she is a birth taken place in the family, she is a one of the co-partner, but some dates are restricted. 1956 before born, she cannot claim. Such one, two or three conditions are laid down in that judgment. Hence, the Prakash has taken the matter before Honorable Supreme Court. These all the dates are overruled. Then Section 6 incorporated. It is by birth daughter is having, because she is a co-partner. Therefore, she is entitled to claim as equal share from the against the brother or deceased father. Any property which is thrown into common stock of joint family entitled, it is a co-partnery property. Therefore, she is entitled equal right. Some provisions are discussed in that section, stating that in that section, the provided the party at a partition in such joint Hindu family, the co-partnery property shall be divided as to allot a daughter. The same share is available to the son. Whatever the son having, the same equal share, the daughter is also entitled. That is the word has been used in the section 6A of Hindu women's property right. Then proviso. What are the terms and conditions laid down in that section? Provided the share which is predeceased son or a predeceased daughter would have got a partition if he or she had been alive at the time of partition, she shall be allotted to the surviving child of such predeceased son or of such predeceased daughter. This meaning says that when she shall claim, because when she is alive, some of the sons were got it partition. Even otherwise, if she was alive as on date of the partition, and if the sons are the children are, they got it effected the partition without knowledge of the daughter can claim even after death of their co-partners, means brother, parents, or anybody else. She can claim wherever the co-partnery property is decided. So therefore, she is also given right to claim partition when she was alive, and partition if it is took place during her status in the family, or she was alive as on the date of partition took place of the predeceased children. So that is also one of the proviso. The second proviso, provided that the share allotable to the predeceased child of predeceased son or predeceased daughter, if such child had been alive at the time of the partition, shall be allotted to the child. Now, the woman is not alive. When the partition was took place, woman's children, if alive, they are also entitled equal share, as if her brother entitled the equal share. That is also provision has been made. Any property to which female Hindu becomes entitled by virtue of provision clause A shall be held by her with the incident of co-partnery ownership and shall be regarded notwithstanding anything contained in the act or any other law for the time being in force. The property capable of being disposed of by her by will or other testamentary disposition, and those property which are allotted by way of will by the co-partners, one of the co-partners, that can be questioned before the court of law because I am also entitled equal share. Nothing, clause B shall be applied to the daughter married prior to or to a partition which has been effected before the commencement of the Hindu Succession Act. If the said act is applicable only after implementation of the act. So that's why I have fixed the date. Kindly maybe look into the date is 2012-2004 and 1/1/2005. This is the date effected, and by way of amended, this section has been incorporated. So when such being the case, she is entitled equal share. So one of the recent case, kindly maybe note down, AIR 2020, Supreme Court, page number 3717, page number AIR 2020 SC 3717. That is the page number. Decided in case of, this is Vineet Sharma versus Rakesh Sharma and other connected cases. It is lengthiest judgment. It was wrote by Honorable Supreme Court. Lordship has been observed in para number 67, 68, 129. These are the paras of this judgment is very important. I want to read the para number 68. Kindly maybe look into how they have incorporated and upheld the amendment. In Fulvati case, some changes has been made in this case. Effect of enlargement of daughter's right. Acquisition of right by co-partnership property. How she has acquired the right of property by way of co-partnership property. It is by birth that interest in the property is acquired. Devolution on the death of a co-partner before 1956 used to be only survivorship. 1956 Act came into force, Hindu women's property right, but not equal right. When this was amended has been made, so therefore it is brought 1956. After 1956, women would also inherit such in existence mentioned in the proviso of unmarried daughter, section 6. Now by the legal fiction, daughters are treated as co-partner. Kindly maybe look into co-partner means son and daughter, one and the same. Now you should not discriminate it. Now what observation in this judgment is made, when the son is married and he don't want to go outside. Daughter is married, she has to live along with her husband somewhere else. But she is a co-partner relating to the co-partner property, even though she is not living along with joint family. But still, co-partner property is concerned, she is having a right. It is by virtue of birth or by way of adoption, obviously within permissible degrees, a person is to be treated as co-partner and not otherwise. One thing before the court of law, the daughter should prove, I am a co-partner of this family. This is the law laid down in this case, Vineet Sharma's case versus Rakesh Sharma's case. Now, important topic they have discussed, para number 69 in this judgment. The argument raised, if the father or any other co-partner died before the Amendment Act 2005, the interest of the father or other co-partner would have already merged in the survivorship co-partner property. and there was no co-partner alive from whom the daughter would succeed. We are unable to accept the submission because it is not by the death of the father or other co-partner. The right is accrued. Right of the woman is accrued because her birth status in the joint family. So therefore, she is succeeded. We are unable to accept the submission because it is not by the death of the father, other co-partner, the rights accrue. It is by the factum of birth. It is only when female class 1 heir is left, or in case of her death, male relative is left, the share of the deceased co-partner is fixed to be distributed by the deemed partition. Now, even otherwise, death of the co-partner, death of the brothers, even she is also died, but still she is entitled for equal partition. And some of the distributed amount. In the event of actual partition, as and when it may takes place, as per the proviso, unamended section 6, the share of surviving co-partner may undergo change till the actual partition is made. The proviso section does not come in the way for formation of co-partner or who can be a co-partner. The section 6 is originally stood contained the exception of survivorship right. The right confirmed under substituted section 6.1 is not survivorship but by birth. What happened? If person died, only the survivor is entitled. That is the old section. Subsequent section, what they have incorporated? No. Not survivor means the legal heirs, class 1 heirs, the son, daughter, wife, son, daughter. They are the survivors. Now, originally it was under section 6, they are entitled the share, some portion of the share entitled by the daughter. Because survivor means she is not survived because Hindu family was there. She is outside because she married and living separately. But subsequently, when 6 section A has been incorporated in the Hindu Women's Right Property Right Act 2005, that she is also entitled. Significant is how right of co-partner is acquired under Mitakshara co-partnering. It cannot be inferred that the daughter is confirmed with the right only on the death of living co-partner. No. Even otherwise, co-partner is alive. After death only she cannot claim. That is not the law. When she is a co-partner by birth itself, she is entitled. And same was survivor as mode of succession of property of a Mitakshara co-partner has been abrogated with effect from 9/9/2005 under section 3. So therefore, this fact has been decided in this case in another para number, effect of the statutory fiction, para number 79 of the judgment. What right to claim partition is significant basic feature of the co-partner, and a co-partner is one who can claim partition. The daughter has now become entitled to claim partition co-partner with effect from 9/9/2005. Please note down this date. 9/9/2005 only she co-partner, she is entitled equal right from the co-partner property, which is vital change brought about the statute. A co-partner enjoy the right to seek severance of status. Under section 6.1/6.2, the rights of the daughter are paripassu with a son. In the eventually of partition, apart from sons and daughters, the wife of the co-partner is also entitled equal share. Even one of the co-partner died, definitely children or wife, they are entitled equal share along with other co-partners. So this was laid down in the para number 79. Now another 129 para it clearly stated that recently we have answered. This is the Honorable Justice. They have answered for particular question raised before the Honorable Supreme Court. The provision contained in substitute section Hindu Succession Act 1956 confirm the status of co-partner on the daughter born before or after amendment in the same manner as the son with the same right and liabilities. The liabilities also, both are equally, they are discharge the liability of the Hindu co-partner properties. If any liabilities on the property, both son and daughter, they have to discharge. The rights can be claimed by daughter born earlier to the effect of 9/9/2005 with saving proviso 6(1) as to the description or alienation, partition or testamentary disposition which had been taken place before 20th December 2004. The proviso what restricted to the daughter, if any disposition, any will or anything partition was took place, that is registered partition should be there prior to 2012-2004. Though even it is effected 9/9/2005, but it is effected 2012-2004 prior to any alienation, any partition took place. Therefore, she is not entitled to question those partition. But by birth, when she is entitled, she has to question only after whatever the property is available among the co-partners. Since the right co-partner is by birth, it is not necessary that father co-partner should be living as on the date of 9/9/2005. That is, whether the co-partner property held by the father, that should be entitled only from the 9/9/2005. So that is also restriction has been made. The statutory fiction partition created proviso section 6 of Hindu Succession Act as originally enacted did not bring about the actual partition disruption of co-partnership. The fiction was only for the purpose of ascertaining the share of deceased co-partner when he was survived by the female heir. Class 1 as specified in the schedule of the 1956 Act, male relative of such female, the provisions of the substituted section 6 are required to be given full effect. This is amendment provision. You should not wait for anybody else if died or any person having co-partner property. But if the partition was not took place among the family members, every daughters are right to claim the partition. Even the some example I want to give you. Though the property having by the co-partner, one of the case I have held in Jayanagar property, the grandfather was having a one property that is 40 to 60. He died. Then he is having two sons and one female daughter. Whether the female daughter can claim, because the property held by two brothers, they want to effect the division, called the daughter, come and execute the relinquish deed, release deed in our favor, because you are also having equal right as per the amended provision act, because till today there is no partition. Then they have neglected her. The both brother got it effected division, half of the property they got it division, that is at Jayanagar. Then I have caused the notice to the parties. Since you have called us before the partition to execute the release deed, subsequently, without our knowledge, you got it executed the partition deed. Though the act came into force in the 9/9/2005, when the partition was not took place, now you want to partition of the co-partner property held by you, of which is the belongs to the grandfather property. I am also entitled because I am also co-partner. Only one son. We are having three sons. That is, two sons and one daughter. So then I have filed a case before Honorable City Civil Court. I got immediately Both of them, they have come before the court. They are saying that, yes, she is a sister entitled for, sir, we have served lot to our parents, and she is living along with her husband, and children are in the abroad. She is getting handsome income. Therefore, she is not entitled. That is the claim of these two brothers. Then I have told, the section does not mean says that though I am having crore to the property, earning everything, but co-personary property, if you are admitted, I am one of the co-personer along with you, definitely 1/3 share, I am right to equal. Then they have come forward to decide. See, two brothers, kindly maybe look into our status. We don't have any house at Bangalore. Therefore, we want to share your property by way of encashment. That is cash. By way of property, by way of cash, we are going to decide your share. Kindly maybe accept. Then we have decided based on the market value of the property, 1/3 share entitled equally more than 1 crore rupees. Then I have asked my client, because being a your sister, you are away from this family for long life you are led along with your husband. At least your brother be happy. You should not demand the market value. Then SR value come and you accept it. Then I convince my client, you accept 50 lakh rupees. You take down, because the brother, the relationship should be continued among you. So therefore, she has accepted 50 lakhs rupees. And kindly maybe look into in that case, that mother died. Then two sons, the grandsons of the great grandfather, they have received money, 25 lakhs each, and got it divided. Because birth of right is concerned. When the co-personary property is there, definitely they are entitled. Even the mother died, the children also they can claim, because they have called for consent of the partition and they have left out. So therefore, I got this way of compromise also. It is necessary, because the advocate's role does not mean that fight equal right is required. No, partition is concerned always flexible in nature. You are become going to a lawyer. We should not stick on the partition, stick on the equal right. Some adjustment by way of cash or by way of some portion of the property which is separated from the main house. Likewise, outside house, if it is available, you can incorporate your right, and you should solve the problem between the brothers. So therefore, the dispute should not be continued. But I want to advise you, the relationship between the brothers and sisters, it should be remain as long as many years. Otherwise, the relationship should not be spoiled. So therefore, I am advising you, this type of case come across, try to get settled by way of mediation, settled by way of your mind, your talent, and solve the problem as early as possible, because you are getting both side claimed. You have the conduct the relationship, coordination of the parties for long ever, that should be continued. Therefore, it is my advice. So likewise, this case, you can read the whole case, that is Vinit Sharma versus Rakesh Sharma, decided AIR 2020, Supreme Court, page number 3317, page number. You go through the All India Reporter, and in that case, beautifully wrote the judgment, how to be decide, how to claim the co-personal right, and what are the provision in that case, how you want to file a case before the court relating to the co-personal property. So I think you understood about the co-personal property, whether the daughter is entitled equal. And another one thing, it has been observed in that case. When the sister born with brothers, you see what observation they have made. That is shoulder. If your brother has come out and next you are coming, they are also having shoulder with each other, equal share. Therefore, you should not decline to grant her share. That is the observation is also made in this judgment. All cases are overruled and fine detailed judgment has been written upholding the section 6A amended in the year 2005. That is 11/2005 and 9/9/2005 it is effected. So therefore, you should aware and go through this judgment and you clarify yourself whether the daughter, how can she claim the partition of the co-personary properties. So I think you understood this section. And another very, very important section is there. The woman's ownership right in which section? That is section 14. So section 14 I want to read because you can understand how the women are having right over the property. That's a section 14. Property of a female Hindu to be her absolute property, who are having absolute right over the property. That is the question, maybe answer during your examination also. The daughter having or any woman having absolute right over the property. Which property? Not only for partition, not only for other rights. So therefore, section 14 I want to read. You please go through this section also. I want to subsection 1. Any property possessed by female Hindu, whether acquired before or after commencement of this act, shall be held by her full owner thereof and not limited owner. Kindly maybe look into granting the right to the woman as if she is an absolute owner. Absolute owner, I think you have read over in jurisprudence, ownership. Ownership means having possession, having a right to alienate, having a right to use, having a right to receive the consideration amount. That is called ownership. So therefore, ownership means, this is you have read over in the jurisprudence, that is the word customs, ownership, possession and everything. These words are you have come across. But ownership, Hindu, woman, female, she may be somewhere else. But how she is having a right, title, possession, right to alienate, and right to receive consideration amount, and right to put possession after selling the property. All these ingredients should be incorporated, called as ownership. So Hindu woman, these are the property. The explanation has been made in this section. In this subsection, property includes, which are the property? Then both movable and immovable property acquired by female Hindu by way of inheritance, that is the co-personary property, or devise, or getting the property by way of partition, or at partition, or in lieu of maintenance. Kindly maybe look into, husband don't want to litigation, he wants to get it divorced from her, and in lieu of the property, in lieu of the payment of money every month, I want to hand over some portion of the property. Kindly maybe take into as a maintenance for your life. That is also absolute ownership. Maintenance for, because we are liar, always instigating the woman, stating that only for maintenance it has been granted, therefore you don't have any right to alienate. Always fighting by the advocates and incorporating or trying to mislead the court, saying that maintenance purpose, if it is allotted, she is not having any right to the property. Therefore, that is not the correct. If the property is allotted for her maintenance, it is absolute right under section 14 of Hindu women's property right. Next, in lieu of maintenance, arrears of maintenance, he can't pay money. Therefore, 1 acre is land available. He wants to alienate to her or releasing his right towards arrears of maintenance. 1 lakh, 2 lakh rupees, if it is arrears, she can claim there is a 1 acre of land. If he has given 10 guntas of land, I am satisfied. So therefore, or in lieu of arrears of payment, if the property is allotted, she is having. These are the properties. And by gift from any person, whether a relative or not, before or her after marriage, her own skill or excursion, by purchase, by prescription, in any other manner whatsoever, also held by her as Stridhana immediately before the Commencement Act. So, 1956 Act, how the women's right has been described, and this section has been incorporated long back, 1956. But what are the properties? She can absolute right. She can enjoy the property. So these are the property she has purchased. She is also owner of the property. Even if she is available in Hindu and she is Hindu Kopasnari family, but she got right to purchase the property because while she is a employee maybe, and she may be advocate, she can earn for her own income, and she got the property, she is absolute right over the property. You cannot question, because we have made contribution by virtue of Hindu family income, therefore she is not entitled ownership. No, if she is purchased, she must show her bona fides stating that it is my hard earning money, therefore I have purchased the property. It is proved, automatically she is absolute owner of the property. Nothing contained section. There is another proviso. Shall apply to any property acquired by way of gift or under will or any other instrument under decree of civil court or under an award of term, give the gift, will or other instrument, the decree or order award prescribed restricted estate in the property. So if the will or conditional will is there, you don't have right to alienate, but you can enjoy. Those such properties she cannot claim ownership. And even otherwise gift has been given only for the purpose of gift has been given. Whatever getting earning from this property you enjoy during your lifetime. Gift, because rental income, it can be gift. So therefore it is not absolute owner of the property. Even gift has been given, transfer of the property has been made, possession has been handed over to her, automatically it is accepted between the parties. But gift, only the rental income, only the movable property has been given, then she cannot claim under the will as well as this one. So therefore, some exemptions are there. These are the two sections, very, very important for practical purpose. Being an advocate, you have to look into to confirm the right of the parties before the court and enlarge them as much earlier, because these are the judgment you have to go through, and because it is remarkable judgment decided Vinit Sharma versus Rakesh Sharma case. Beautiful judgment has been written. First thing I want to say, I am thanks to my Honorable Justice Kumar, because he wrote first day that judgment throughout India in Karnataka, the first judgment it was started. Honorable Justice Kumar given the woman's right, rightly given, but subsequently some restriction he has, Honorable Justice has made. Before 1956 burn, she is not entitled for Kopasnari. Some restriction, those are modified in the Vinod Sharma's case. So, first case, I am appreciate that our own Honorable High Court decided in Fulavati versus Prakash. Then it went to the Supreme Court, Prakash versus Fulavati. And all the cases are scrutinized, and each and every point throughout India, wherever it was decided. And in this case, so many judgments, more than 45 judgments are decided in this case, because simple judgment is also there, and you can read these. I have paragraph I have read 68, 69, 179 and 123. Likewise, if you those pages, you can grab your mind to say that yes, I can ascertain the right of woman, and I can ascertain section 14, who is absolute owner. These are the two sections for your partition is concerned. Go before the court. Calmly you tell, calmly you address the argument. Yes, sir, it is my absolute right, sir. I am a co-partner, sir. I am entirely equal, sir. This is the practice you have to render. Definitely no problem at all in your life, because you must please before the court. You must plead before the court. Humbly plead, because you see, when client comes to us saying that Yalla nimage kotbitidini Swami, because she has executed wakalat. And when she has executed wakalat, we are filing before the court, and we are always, Your Honor, beg to appear before Honorable Court on behalf of my client, Your Honor. That is, the justice can be rendered when we are placing the material before the court. Good material you should collect and place the matter before the court. No problem at all under those two sections. Very, very important for practice purpose. Thank you very much. Is there any question? Please ask me.
Sir, as an exemption, you mentioned with respect to the point of will.
Yes.
Could you please elaborate on that, sir?
Yes. Now, I am having immovable property. I am bequeathing the property, stating that my son is entitled absolute ownership. My daughter is entitled equal share between them for income arise out of the property. In such cases, the woman cannot claim as if absolute right over the property. This is the differences. Now only daughter is there. Now today itself, if he has bequeathed the will and he is alive, daughter saying that no, I am not getting any income because you are entitled, you have bequeathed the property. During lifetime, I cannot enjoy the property, enjoy the benefit. I am only daughter. You please provide me, because it is self-acquired property of him. He can dispose of by way of will, by way of gift. Wherever the self-acquired property will is concerned, it is restricted, made in the will. Definitely, she cannot claim under section 14 of Hindu woman's property right. I think you understood?
Yes, sir. Could I ask a follow-up question, please?
So now, what you have asked me, whether property has been bequeathed under will, whether she is having absolute right or not. Some restriction always is there. During lifetime only, he has to enjoy. After death, this particular property goes to daughter or son or everybody. If the division was took place by self-acquired property by way of will between the children, they are having absolute right, whatever share allotted under the will. If the restriction has been made to the daughter, saying that absolute ownership of the property, half of the property goes to one son, half of goes to the property another son, but daughter is entitled only 1/3 share, income arise out of the property. Now, one example I want to give you. That is, areca trees land is available. Every year, definitely accrue the income more than lakhs together. Then bequeathing the will, whatever the earning arise out of the areca trees, all the three should be divided. And afterwards, if the income is not there, the both brother can enjoy the equally. That is under the will. If such a recital in under the will, she cannot claim absolute right against the brother. That is always will in your mind. You should be aware that it is only a self-acquired property.
Thank
I
I
you.
have
think-
a question, sir.
Yes, sir, please.
Um, so Hindu family, I mean, at the beginning, Hindu families are very much like joint families. And let
Yes.
us say the daughter, when they were in a joint family, the daughter had purchased some property from her own earnings, hard-earned money, and that was being used as a joint property by the entire family.
Sir,
Now, after the father mother's demise, when the property separation happens, how this case is being
so
looked into?
one thing, I think you are you must know that blending into common stock. If I am earning in a joint family member, even woman has earned the property in a joint family, even her income is there. But if she has thrown into this joint family, saying that we are all entitled equal share, because she has thrown into common stock, means now some of the properties are available, other properties are available. Main property we are living together, and she has no objection because this is the house property I have purchased, and we are all enjoying. Therefore, it is commonly it can be divided. It can be accepted.
Yeah,
Thrown
I
into
totally
common
agree, sir.
stock. You must aware these words: blending into common stock, throwing into common stock.
Okay.
Hmm.
Sir,
Otherwise,
I got one doubt, sir.
otherwise,
doubt.
section 14 is operated. Yes, sir.
Sir, can you hear me?
Sir,
Sir, you said the daughter's share will be 99/2004. Is the marriage or birth, sir?
birth, not marriage, sir. She is a co-partner property. It is amended act in the year 2004, 2012-2004, effected on 9/9/2005, 2005 onwards. If there is no partition among the family members, and being a co-partner, she can claim right over the property. Co-partner property, that is called as joint family properties. Co-partner
So it
property
means
is
whoever took the birth after 2004, that will get automatically the property.
automatically she is entitled. And
Thank you, sir.
earlier also, sir, by birth, if the partition was not took place, if alienation is not made, always she is entitled equal share.
Hello,
Yes,
sir.
sir.
I have a question, sir.
Please.
Yeah, my name is Rupesh.
Yes.
So you said, as my friend asked, after 2005, so any person where the partition has not taken place, they can claim for that property. So what if the person, for example, if the property belongs to grandfather and he has not given the property to his daughter?
Sir, exception is there. Just to look into exception. Two exception. Partition, alienation made prior to 9/9/2005. If it is made,
Mhm,
partition or anything under registered document,
mhm.
now I have given example to you. After partition, what happened? We being advocate, what we have suggested or we have advised them, some of the brothers, though they have developed, fully developed, but there is no partition which is belongs to their grandfather. But pan parikat, unregistered document they have created before the act came into force.
Okay.
Unregistered partition, that can be questioned by the daughter. No, for the purpose of denying our right, this partition, unregistered partition has been prepared, therefore I am entitled equal right. That has to look into the document.
Okay. And what
Ah.
if the person who has born before 1960, so she can't claim, right?
1956, before 1956,
So
not
there is no
claim.
chance at all. There's no
There is
chance
no
at all.
chance at all. After 1956 by birth. Therefore, the shoulder to shoulder shown in this section by way of amendment.
Okay.
Okay.
Okay, sir. I got it. Thank you.
Welcome, sir.
Hello, sir. This is Bindu.
Yes.
I wanted to know, okay, now that we are discussing Hindu Succession Act, does this also apply to women who have married out of their religion? That is, she is no longer a Hindu. She is maybe a Christian, maybe a Muslim, maybe a Parsi by
No,
way
madam.
of marriage.
No,
So it's gone, right?
one thing I want to entitled to say, even if she is married to somebody else, but if being a Hindu, she can claim. Because if until and unless she must show, I am a Hindu woman, then only she is entitled equal right.
Yeah. Okay, got it, sir. Thanks so much.
Welcome, madam. Because Hindu word, in that preamble, this section says, just I want to tell you what preamble says in Hindu Succession Act. Any person who is a Hindu by religion, in any its form or developments, including Veerashaiva, a Lingayat, or followers of Brahmo, Prarthana, or Arya Samaj. These are the persons. And to any person who is a Buddhist, Jain, or Sikh by religion, and to any person who is not a Muslim, Christian, Parsi, Jew by religion, unless it is provided that any such person would not have been governed by Hindu law and by way of custom or usages as part thereof law in respect of matter of dealt with here in this case, not been enforced. I think you understood this section.
Yes, sir. Yeah, because when we were doing Hindu law, this was
Yes.
clearly mentioned. So I thought I should
Yes.
just check on
Yes.
this particular aspect as well.
Please,
Thank you
please,
so much.
please. Welcome, madam. Thank you.
Sir, this is Satyanarayana. I have one question.
Yes.
So
sir.
you mentioned that the shoulder share and all. Why it took the 50 years to figure out that?
Because what happened, now she is married. Now 2 daughters are available. One daughter married and living separately. Another daughter says that I am absolute owner. Therefore, this dispute controversy started among the family. They don't want to provide. Because the word I have told you, Kothen Kulukhoraked, that is the word has been used in Fulvati case. Illa, that is not the word you should not use. She is not outside the family. She is inside the family. That is the Fulvati versus Prakash case dealt by Honorable Justice Kumar. That is the shoulder. Because, sir, the changes of law, changes of the demands, changes of the demand, pendency of the cases, then law should be envisaged under the enactment. Otherwise, it is very difficult, sir. How we are going to claim right? Because under Constitution, there is a guarantee, but should claim by way of right through the enactment only. Therefore, it is incorporated after long back. 56 Act has been amended 2005.
Sir, Suman sir.
Yes, sir.
Sir, nothing. Sir, there are some things like in Muslims, they get it from their Quran, like this thing has to be done. In
Yeah.
Hindu, how was the older times before this?
Sir,
was
customs
rules.
and uses, sir. Customs
Customs
by way of customs. We are Hindu. We have to prove customs. Only based on customs.
Sir, one more thing, sir.
Yes.
If there is a joint family of agriculture,
Yeah.
they have 2 acres of land.
Yes.
The woman is a married girl and she lives a luxurious life, but she doesn't want to do agriculture. Now, the boy gets his brother gets a half of its share, the equal rights, and now he used to grow in 2 acres. Now she takes off 1 acre and she does something sides or something and gone. What about the agriculture land development, sir? Is this a becoming a very problematic in
Sir,
future.
section 94 come across the Land Revenue Act. The deputy commissioner, if any agricultural land made the application under section 94 before the deputy commissioner, whether this land is permissible for farming the layout or development for non-agricultural purpose, it is restricted under the law. That is Karnataka Land Revenue Act. So therefore she can do, sir, because when she has got right 1 acre, she can, because even though he is agriculturist, but
Yes, sir. Yes, sir. Yes,
cannot-
sir. I agree with that. But
Mhm.
if this thing becomes a future problematic,
no problem, because the permission is there. She her right. I want to develop by way of non-agricultural purpose.
ಸರ್ ಈಗ
Definitely
ಈಗ ಒಂದೇ ಒಂದ್ ಮಾತಾಡೋಣ. ಈಗ
Yes.
ಲ್ಯಾಂಡ್ ಬಂದು ಕೋಲಾರಲ್ಲಿ ಇದೆ,
ಹೌದು
ಇವ್ರು ಬಂದು ಬೆಂಗಳೂರಲ್ಲಿದ್ದಾರೆ.
ಹೌದು.
ಈಗ ಅವ್ರು ಬೆಂಗಳೂರಿಂದ ಬಂದು ಕೋಲಾರಲ್ಲಿ ವ್ಯವಸಾಯ ಮಾಡ್ತಾರ? ಅವ್ರು ಮಾಡಕ್ಕೆ ಬೇರೆಯವ್ರನ್ನ ಬಿಡಲ್ಲ.
ಸರ್, ನಾನು ಈಗ ನಂದು ಪ್ರಾಪರ್ಟಿ ನನ್ನ ತಂದೆದೆಲ್ಲ ನಮ್ಮ ಊರಲ್ಲಿ ಇದೆ. 8 ಎಕರೆ ಇದೆ. ನಾನು ಇಲ್ಲ, ನಮ್ ಬ್ರದರ್ ಇಲ್ಲ, ಮಾಡ್ತಾ ಇಲ್ಲ. ಯಾರನ್ನೂ ಕೊಟ್ಟಿದೀವಿ, ಪಾಪ ಯಾರೋ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ನಮ್ ಬ್ರದರ್ ಕೇಳಿದರೆ ಡಿವಿಷನ್ ಮಾಡ್ಕೊಳೋನು. ನಮ್ ಬ್ರದರ್ ಈಗ ಡಿವಿಷನ್ ಕೊಟ್ರೆ ನಾಳೆ ಮಾರಾಟ ಮಾಡ್ಬಿಡ್ತಾರ ಅಂತ ಹೇಳಿ ನಾನ್ ಡಿವಿಷನ್ಗೆ ಹೋಗ್ತಾ ಇಲ್ಲ. ಅದಕ್ಕೆ ನಾವೇನ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಿ, ಏನೇ ಅರ್ನಿಂಗ್ ಬಂದ್ರು ನೀನೇ ತಿನ್ನು ಹೋಗಪ್ಪ ಅಂತ ಬಿಟ್ಬಿಟ್ಟಿದೀವಿ. ಹಂಗಾಗತ್ತೆ ಸರ್. It is understand between the brothers, those who are having right, our sister also, because she is a co-partner entitled by way of act, sir. Equal right.
ಒಟ್ನಲ್ಲಿ ಫ್ಯೂಚರ್ ಅಲ್ಲಿ ಇನ್ನ ಏನಾಗುತ್ತೆ?
Ayo, don't know, sir. Allah, every day, Allah, law is changes. You see, Lordship Justice Kumar dealt in the year 2000. I think this 2020, that is in the year 2005 ಏನೋ, ಅವಾಗ್ಲೇ ಅದು ಬಂದು ಅವ್ರ ಕೈಯಾಗ ಬಂದು ಭಾರಿ ಬ್ಯೂಟಿಫುಲ್ ಜಜ್ಮೆಂಟ್ ಬರ್ದಿದ್ದಾರೆ. ಖುಷಿ ಆಗುತ್ತೆ ನನಗೆ.
ಇನ್ನೊಂದು ಸರ್, ಒಟ್ನಲ್ಲಿ ಹಿಂದೂಸ್ಗೆ ವೇ ಆಫ್ ಲಿವಿಂಗ್ ಮೇಲೆ we decide how we live.
And yesterday also, just one example I want to give you. One of the daughter filed a case before Nagamangala case, and only one brother, other 3 sisters are there. 3 sisters are supporting one brother. Brother was a driver in Codes department.
Okay.
He has earned huge property in his name, because Codes, I think, no more income. Being a driver, he has earned. And he has purchased the property in his wife's name. And all the properties are adjacent to each other. Co-partner property, only brother. Now only sister filed a case. And she is demanding. Now just says that Mr.N.R.Naik's case, it is very clear. She is entitled, and she has questioned all the sale deeds executed in favor of his wife.
Oh my God.
All the earnings of, because property he has purchased adjacent to our property only.
Yes.
Because whatever the income arise out of this property, he has purchased in the name of his wife. Wife is also made as a party. It is so I have proved that case. Now judgment posted on judgment. I have relying on this judgment only. Mr.N.R.Naik's case.
Sir, sorry to interrupt, sir. I have a question on this.
Yes.
You said that particular property which is purchased by the driver, it is adjacent to the co-partner property.
Yes.
But what if that driver proves that he has purchased out of his
He
income?
unable to prove, sir. Income, his salary, only meager salary, but his income is more in Codes Bank.
Yeah. He can't prove by illegal ways.
Yes.
Exactly. Good point, sir. Yeah.
Well, so you have to, because I am a practicing advocate, therefore I am giving example to you.
Yeah. Thank you.
I have filed so many cases likewise. So because this is the judgment I am relying now, every court is deciding based on this Vinod Sharma versus Rakesh Sharma's case. Every day disposing of. The point of law, only one point, that's all.
Sir, whether grandchildren have a right to their grandmother's property?
If it is not partition among the co-partners. Only one single point, because predeceased, always that word has been used in the proviso, madam. If the partition should not be happen, because alienation for the purpose of Hindu male member sold some of the properties. Therefore, legal necessity, because for the performance of marriage, for the development of another property, likewise may be sold. But those property cannot be included as if she is entirely equal. Say they have to defend, because this purpose my father was sold during lifetime for legal necessity. Matter is end. You are not entirely equal there.
Sir, what if the grandchildren, whatever she asked, she is like born after 1960 and sale deed is not executed?
Sir, 1956 onwards, there is some right. Hindu Succession Act, it is there.
Okay.
Indian Succession Act is affected.
Mhm.
Now this particular section is adopted, 6A of Hindu women's property right. So therefore, equal right is always available, sir. Now I have
Sir.
filed a case. I have filed a case aged about 80 years.
Okay.
One Muniamma. I have filed a case against her brother. Her brother died just and having 23 acres of land. I have got equal right judgment. 1998 I have filed, subsequently amended section 6 applicable, and immediately decree has been passed, and decree upheld by the Honorable High Court in a regular appeal. Everything is over. Now I have filed final decree proceeding. I got the partition equal right.
So the age is with respect to co-personary or
Yes, by
with
birth.
respect
Word, please note down.
Yes, sir.
Birth.
Or it is applicable for grandchildren also, sir. The age.
Yes, yes. If there is no partition.
Yeah, there is no partition, and the age of the father is not available, and
Yes.
it is applicable for grandchildren also.
Yes. 9/9/2005. It is very, very important date.
Thank you.
Welcome, sir. I think you understood both sections. Just imagine what are the rights of woman property and what the property she can claim. Co-personary property is differ, and whatever property she has earned by way of sale, by way of partition, by way of these are the self-acquisition property. Now I want to say one thing to you. When you got the property from by way of partition, how can you say that you are the absolute owner? Just I want to inform you, Hindu woman's right over the property. She got the property, but children cannot claim. It is joint family property because you got the partition, therefore we are entitled equals. No, it is her property. I think you understood the difference between the property, how it is devolved. The grandchildren cannot seek partition against the mother when she is absolute right by allotting her co-partner property. I think you understood the para, how section 14 hit by law. Hello?
Sir, I have one question.
Yes.
Yes, say for example, my father has a property wherein if my mother was expired, so when the distribution happened, it will be taken as my mother's siblings or based on the grandson's count.
See, sir, this property died by mother's property. She is only having right over the property. You cannot claim partition on that property.
No. What I'm saying, my grandmother.
Yes, grandmother having ownership. She has an only daughter, and children wants to claim partition against mother. No, it is absolute right of the mother property. Absolute right always, ladies.
Okay, there is a small error. So it is not a grandmother property. It is a grandmother father property.
Then it is co-personary property, automatically entitled by the children. Co-personary means, just you look into, co-personary means head of the family. She is one of the member of the family. Therefore, she is entitled equal share.
Why I'm asking, like, if my mother is not there, but my grandmother children are there.
Just one example I want to give you. Definitely you are clarified this. You see, father died. Getting mutation khata. Getting mutation and khata in our name. Whether khata carries out the ownership, whether mutation carries out ownership, no. Khata mutation, no. Testamentary document should be there. Either will, if that is the testamentary document. If it is not there, automatically it is nothing but co-personary property. I think you understood now.
Yes.
Yes. Is there any question?
Sir, one more question, sir. Sir, whatever the by birth they are getting, the women's what they are getting from by birth, it's from ancestor property, right?
Co-personary property.
Ancestor's property. Sir, what happens if she gets her rights and she gets her property from the ancestor, and she doesn't do anything? She doesn't sell it, or she doesn't do anything, any transactions to anyone.
Yes.
Now, if the sister, the woman had a brother and his son, can he claim that property? Because it's an ancestor property.
Sir, co-personary property by way of division, automatically division goes to them. Automatically by way of co-personary property. Now, mother's mother property, it cannot be.
Mother's mother, okay.
Yes.
Mothers cannot be.
Cannot be claimed.
If the mother's father's?
Mother's father co-personary property, Hindu joint family property.
Sir, ಅರ್ಥ ಆಗ್ತಿಲ್ಲ ಒಂದು ನಿಮಿಷ.
ನೋಡಿ, mother's father ಆದರೆ automatically she is one of the co-personer of that family. Mother is having property belongs to her father. Then mother cannot claim as if she is owner. Automatically that property is divisible.
No, sir. Now you told me one word. Before this, the grandchildren can have a right.
Yes, definitely. Because grandchildren, why they are having? Because it is grandfather's property. Equal share.
They get two grandfathers, right?
Yes, through grandfather.
From mother side.
Yes.
Can they do it from which side? From mother side.
From grandfather's property they can claim, not mother's property.
Yes, sir. That's what I needed.
Yes.
Sir, ಇದನ್ನೇ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಸರ್ ತಲೆ ಕೆಡ್ತಾ ಇದ್ದೆ. ಈಗ ಅವ್ರ ಅಮ್ಮ ಅಂತಾರೆ, ಇವಾಗ ಹೆಣ್ಮಗಳಿಗೆ ಶೇರ್ ಹೋಗಿದೆ, ಅರ್ಧ ಶೇರ್ ಹೋಗಿದೆ.
ಹೌದು.
ಮತ್ತೆ ಅವ್ರಿಗೆ ಅಣ್ಣನ ಮಕ್ಕಳು ಎಲ್ಲ ಇದ್ದಾರೆ.
ಹೌದು.
ಅವ್ರ ಏನ್ ಮಾಡ್ತಾರೆ, ಈಗ ಹೆಣ್ಮಕ್ಳಿಗೆ ಹೋಗಿರೋ ಶೇರು ಏನು ಆಗಿಲ್ಲ, ಇಟ್ಸ್ ನಾಟ್ ಯೂಸ್ and it's undivided. You told me undivided property. If there is an undivided property, it can be put a case. Now, if the brother's children, can they occupy that? Because it's an ancestor property.
No, they are trespasser. Because you see, even if the division was to place brother and sister, and it is wasted property because she don't want to improve that property, then they cannot claim as if she is not used until and unless she relinquished her right in their favor.
Now the property goes to their family tree.
Yes, her family.
Her family tree.
Yes, sir.
Okay, sir. Hindu law changes everything, how we live, right? Okay,
the advocates are beneficiaries, sir.
Thank you, sir.
Thank you. Welcome.
Sir, I have a question, sir.
Yes, madam.
Sir, just now you told relinquished. Relinquished means is that
released it? Released it. Relinquishing her right, whatever right she has accrued. release deed or relinquishment deed. These are the two documents she is having to release her right which she has acquired.
Sir, can that be done sir ಮುಂಚೆ ಹರ್ಷಣ ಕುಂಕುಮ ಅಂದ್ಬಿಟ್ಟು ಕೊಡ್ತಾ ಇದ್ರಲ್ಲ ನಮ್ ತಾಯಿಗೆ ಅದು ಆತರ
ಅರಿಶಿಣ ಕುಂಕುಮ ಕೊಟ್ಟದ್ದನ್ನ ಕಾಳೆ ವರ್ಸಸ್ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾದಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬ್ಯೂಟಿಫುಲ್ ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಫಾರ್ ದ ಹರ್ ಪ್ರಾಪರ್ ಪಾರ್ಟಿ, ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಗಿಫ್ಟೆಡ್ ಪ್ರಾಪರ್ಟಿ. ದಟ್ ಅರಿಶಿಣ ಕುಂಕುಮ ಕೊಟ್ಟಂತ ಪ್ರಾಪರ್ಟಿನ nobody can claim. It is her own property. ಯಾಕಂದ್ರೆ ಟುವರ್ಡ್ಸ್ ಮೇಂಟೆನೆನ್ಸ್, ಟುವರ್ಡ್ಸ್ ಗಿಫ್ಟ್, ಈ ತರ ಕೊಟ್ಟಂತ ಪ್ರಾಪರ್ಟಿನ ಇಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಅರಿಶಿಣ ಕುಂಕುಮ ಪ್ರಾಪರ್ಟಿ. ಇಟ್ ಈಸ್ ಗಿಫ್ಟೆಡ್ ಅಂತ ವರ್ಡಿಂಗ್ ಬಂದಿದೆ, ಆ ಕೇಸ್ ನಲ್ಲಿ ಡಿಸೈಡ್ ಆಗಿದೆ.
Sir, but that was registered, sir. Like actually the part was purchased
one thing you should aware, 1996 our own honorable justice decided the fact that the unregistered partition deed cannot be accepted in any manner. That law is upheld by the Supreme Court. So therefore, it shall be registered. But wherever the Arshina Kunkuma means, all persons are accepted. Nobody has questioned. Father is giving the right to the daughter by way of Arshina Kunkuma. It cannot be questioned. Nobody can question.
ಸರ್ ಅದ್ರಲ್ಲಿ ರಿಲೀಸ್ ಡೀಡ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಸರ್. ಅದು ಆ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಬಿಟ್ಟು ಅದರಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಸೆಡ್
ರಿಲೀಸ್ ಡೀಡ್ ಮಾಡ್ಬೋದಲ್ಲ. ಅದರಲ್ಲಿ ಅರಿಶಿಣ ಕುಂಕುಮ ಕೊಟ್ಬಿಟ್ಟು ಇನ್ ಉಳಿಕೆ ಯಾವ್ದು ಪ್ರಾಪರ್ಟಿ ನಾನು ಕ್ಲೇಮ್ ಮಾಡೋದಲ್ಲ ಇನ್ ಮುಂದೆ ಅನ್ನೋದು. ಯು ಶುಡ್ ನಾಟ್ ಕ್ಲೇಮ್ any other property.
Yes, sir. That's what it has happened. My mother has not realized ಆ time ಅಲ್ಲಿ ಅವ್ರು ಆತರ ಮಾಡಿದಾರೆ ಅಂತ ತಿಳ್ಕೊಂಡಿರಲಿಲ್ಲ. But recently it was 30 years ಆದ್ಮೇಲೆ somehow we saw that document.
ನೀವ್ ಏನ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಆ ವರ್ಡ್ ನ it is hit by section 6A. Therefore I am entitled for partition in respect of co-personal property ಅಂತ ಕ್ವಶನ್ ಮಾಡ್ಬೇಕು.
ಕ್ವೆಶ್ಚನ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸರ್. ನೋ, ಶಿ ಡಸಂಟ್ ವಾಂಟ್ ಟು ಕ್ವೆಶ್ಚನ್.
ಅದೇ ಬ್ರದರ್ ಅಫೆಕ್ಷನೇಟ್ ಇರುತ್ತಲ್ವಾ?
ಇಲ್ಲ ಸರ್, ಅಫೆಕ್ಷನೇಟ್ ಅಂತ ಇಲ್ಲ. ನೋ, ನಾಟ್ ಬಿಕಾಸ್ ಆಫ್ ಅಫೆಕ್ಷನ್. ಶಿ ಡಸಂಟ್ ವಾಂಟ್ ಇಟ್ ಅಷ್ಟೇ.
ಎಸ್ ಎಸ್
ಬೇಡ ಅಂತ.
ದೇ ಆರ್ ಸ್ಟಿಕ್ ಆನ್ ಆಗ್ಬಿಡ್ತಾರೆ. ನಾವ್ ಏನ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ವೆಲ್ಕಮ್ ಮೇಡಮ್.
Hi sir, I have a doubt sir. My name is Serin.
Yes madam.
Sir, my father made a registered bill in 2013, okay,
yes.
in my name.
Yes.
My house. And he passed away in 2014, almost one year.
Yes.
Only he registered that bill, and it's a self-acquired property.
Yes.
Okay. And is it possible for my sisters to claim it in future, like?
No. But only thing, agriculture land. One difference you just note down.
Okay.
For agriculture land is concerned, you have to get a probate. For residential house is concerned, you need not get a probate also.
Oh, okay. Sorry, sir, can you say probators?
Yes, probate you can claim in respect of agriculture land.
Okay. But it's a residential house, sir. Our family.
House you need not worry, because it is self-acquired property always. Anybody can he bequeath. Anybody can.
Anybody can?
Can take the property by way of will.
Okay, it's registered in my will.
Then no problem. Now self-acquired property means absolute right of him. He is transferring by way of will, because ichha means will. He can give the property to anybody else, not only you, but anybody else.
Okay, sir.
Right.
Thank you, sir.
Welcome.
Hello, sir. I have a question, sir.
Yes, sir.
Sir, ನಮ್ಮ ತಂದೆ ಅವರ ತಾಯಿ, ಅವರ ಅಣ್ಣ ತಮ್ಮಂದಿರು, so they have not given any property to my grandmother. It means my father's mother.
Yes.
We had around 20 to 25 acres property.
Yes.
Now, can we claim, sir? Like ನಮ್ಮ ತಂದೆಯವರು ಇಲ್ಲ ಅವಾಗ, so can we claim as a grandson?
If it is a co-personal property, definitely you can claim, sir.
But as you said, there are two conditions, right? One is partition, the other one is age. So can you please explain on that, sir? Can we claim? Can I?
Sir, only one thing. What you are now mother's property you are telling.
Yeah.
Mother's property is inherited to the children. The brothers are enjoying this property. She is also one of the co-partner.
Not mother, sir, grandmother.
That is grandmother's property only, I am telling.
Okay.
Because mother, only daughter or daughter, only daughter, if is there, it is absolute property of her. But some children are there. Because what happened, one example I want to give you. I being a employee, I don't want to get the property in my name. I am getting the property in mother's name. It is commonly we are using the property. After death of her, all the persons who are enjoying jointly automatically entitled equal share. Because mother's property, only daughter, she cannot claim it is my mother's property. No. The children's, when the male children's are available, automatically the property goes to all the persons. Because the exemption section 14 is concerned, gift, bequests, everything. These are the documents, gift, maintenance, arrears of maintenance. Likewise, if the mother bequeath the property by way of will or anything, so it is, you are also entitled equal shares, huh? Co-partnership property.
Sir, sorry to interrupt you, but doesn't the 1956 rule apply here? Because he's talking about his grandmother, right?
Grandmother, madam, grandmother, how she has acquired that property. You see, one case I want to give you. The Hanuman Nagar one case, she has acquired the property by milk vending business. And after her death, all the children enjoy the property. 8 children, they are enjoy the property. 8 children having, they want to give the property for development purpose and putting up apartment. Then one of the sisters, she has objected. First you decide how much share I am entitled. Then all the children, they have objected by only sister. Other sisters are there, but she has objected for that. Then she filed a case. It is decided in her favor. She is also one entitled 1/8 share. Then they have no option to leave whatever development they want to propose for that.
So these rules are in the 2005 Act in a Women's Act.
Sir, inheritance, sir, by way of inheritance, 99/2005 onwards, equal rights, sir. There is no division among them. It is mother's property. Just Hindu Succession Act, there is a class Schedule 1, Schedule 2. Who is the class 1 here? Who is the class 2 here? Just you go through the schedule. Who are coming in the schedule? Wife, son, daughter, husband, all these things are available in this. Just you go through the schedule. Who are they? Then you can easily find out who are entitled to file a case against all the properties by way of inheritance.
Okay, sir. Thank you, sir.
Welcome.
So
Shall I
can
close,
we-
sir? Yes.
Sir,
Last,
So,
please.
yeah. So can we conclude like this way, even it is the property of great grandfather, if it is not been partitioned, still the great grandson, children still have the rights to go
Yes,
and
sir. Definitely, sir. Definitely. It is by way of inheritance or co-partnership property.
okay. Thank
Hindu
you, sir.
joint family property, ancestral property.
Thank you very much, sir.
Sir, one difference kindly may be note down. Which is the ancestral property, which is not an Hindu joint family property. I want to say, A died, leaving behind B and C. It is a joint family property. I think you understood. A died, leaving behind B and C are the legal heirs. Both are entitled equal share. Is it? It is called as joint family property because though the father having self-acquired property of him during his lifetime, he has not bequeathed the property by way of will. He has not executed any testamentary document, anybody's name. Then it is called as joint family property. B and C are entitled equal share. This is joint family property. Ancestral property. A is the great grandfather having two sons, B and C, and A died, B and C died, then other B and C's children who are third degree children, it is called as ancestral property, which is inherited from ancestors. I think difference you understand.
Yeah, sir. What if the case of B and C is one male and one female?
Whoever may be, sir. Whoever
Okay.
may be.
Yeah, I got it, sir. It's clear now.
Yes, that is the example you have to read through the section wise. Inheritance section, Indian Succession Act. It is Hindu Succession Act, woman's property. Woman's right, today I have taught you what are the rights of the woman.
So in that case, sorry, sir, I have one more question because it's
No
getting
problem,
interesting
no
now.
problem. I am
Only
free
one
today.
question. Yeah. So in that case, when we are talking about self-acquired property, if there are grandchildren already in the picture, and the father decides to give to one kid, maybe a kid whom he favors, can't the grandchildren contest against it?
It is beautiful question you have proposed to me. One thing I want to say, my grandfather, it is not self-acquired property of him. We are earning member at that time when he was purchased. We have contributed the consideration amount by our earning. Then only we are entitled. So now, even though the sale deed stands in the name of grandfather, but whatever contribution made, now you see, at the age of 16 or 20, it is not a grand family, it is not a self-acquired property, it is not a joint family property. If it is property purchased by him at the age of 50, when we are there and we are earning member during that time and stands in his name, then you must prove that this is the contribution we have made and he is the karta of the family, therefore we have purchased in his name. And we are also entitled equals. That type of, this is only in your mind. You should, being a lawyer, how to plead before the court. I think you understood, madam?
Yes, sir. Thank you, sir. Yeah.
Welcome. Shall I close, madam? Is there
Yes,
any?
sir. From my side, it's clear, sir.
Very nice. Thank you. I think you understood. Remember that whatever right is accrued and what are the rights are available. Definitely the question is going to impose when the Hindu rights, women rights come into across. These are the data I have given, and you go through the Vinod Sharma's case, easily available for you wherever you go, because in our college library is also available. In wherever you go, courts are also available. You get the Xerox copy. In every library, there is a Xerox machine. You get that judgment and you go through and you can write by placing this Vinod Sharma's case and you get a good marks in your examination. Thank you for you. And it is also helpful for your practice. Thank you, everybody. And those questions. Welcome.
Thank you very much, sir.
Thank you, sir.
Thanks a lot, sir. Thank you.
Thank you, sir. Thank you.
I think you are going to get this episode on Tuesday. Once again, just to clarify it and say your colleagues, these are the rights are available and you should advise the people in a proper manner. It is better for your prospectus. I think so. Thank you very much.
Thank you, sir. It was a very informative session.
Welcome.
Your experience really matters.
Thank you. Thank you.
Thank you, sir. Bye, sir. Good night, sir.